Back on the record, and Mr. Elmo.
Thank you very much, Madam Chairperson, and may it please the Board. If this plant were needed, which it is not, this would be a different case. If the plant were needed, which it is not, you would have the difficult task of balancing the need for the plant and the electricity from it for system reliability, for the known environmental harms including, but not limited to, carbon emissions. Since the plant is not needed, this is an easier case. CLF's case will present evidence on 4 major points. The first 3 of those 4 major points will be presenting witnesses. The second is sort of a more overarching theme. First, we'll present evidence on the fact that the plant is not needed. Second, we'll present evidence on the issue of carbon emissions and climate impacts. Third, we'll present evidence on non-carbon environmental impacts, including, importantly, biodiversity and forest connectivity. We'll have witnesses on each of those 3 points. The fourth, rather more overarching theme is that we will put into the record, based on record evidence, facts that show that Invenergy has lied to the EFSB, lied to ISO New England, and lied to the public, so that even if a plant, some plant, were needed, this would not be the company to build that plant. So first, we talk about need. And the big question that will leap to mind immediately on the question of need is, how can CLF say that the plant is not needed in the teeth of the PUC advisory opinion of August 3rd, 2016, that said clearly and unequivocally that the plant is needed? Mr. Blazer quoted and cited from that PUC advisory opinion fairly and accurately. The answer to that question is found in the pre-file testimony of CLF's witness Robert Fagan, principal testimony, which is CLF's Exhibit 3. Mr. Fagan lists 6 specific ways in which new evidence available from the ISO, which was not known at the time of the PUC advisory opinion, wasn't knowable at the time of the PUC advisory opinion, shows that the plant is not needed. I handed up to the bench through Ms. Lucarelli a sort of index to Mr. Fagan's 6 points. This is not an exhibit. We're not going to move it into evidence. But it's sort of a crib sheet going through where in Mr. Fagan's pre-file testimony each of those 6 points appears. For example, the PUC advisory opinion found, and I quote, "There's a need for the plant because there is no assurance that any of the other proposed new resources will be built," unquote. This is no longer true. Since the PUC advisory opinion was issued, we now know that the Bridgeport Harbor 5 gas combined cycle plant is now under construction. The Canal 3 plant was permitted by the Massachusetts EFSB in June of 2017. West Medway 195 megawatt plant was approved by the Massachusetts EFSB in November 2016. The express conclusion of the PUC that there is no assurance that these other resources will be built is no longer true today. The PUC found that new demand resources could not take the place of Invenergy. But since that opinion was issued, in Forward Capacity Auction FCA 11, conducted in February 2017, after the PUC opinion was issued, the ISO cleared 640 megawatts of new demand response, larger than the entire capacity supply obligation, CSO, that Invenergy had acquired. That's just one auction. Then the next year, in FCA 12, after the PUC advisory opinion, the ISO cleared another 514 megawatts of demand response. The PUC's conclusion that DR cannot replace Invenergy is out of date. The PUC found that capacity needs are driven by net peak load forecasts. The ISO's 2017 CELT report, CELT is capacity, energy, load, and transmission. 2017 CELT report shows decreasing need for capacity and decreasing net peak load over the next 10 years. And the final draft for the 2018 CELT report, capacity, energy, loads, and transmission, again shows decreasing net peak loads for the next 10 years. It is no knock on the one-member PUC that issued the advisory opinion that it did not know things that were in the future, because the PUC is not clairvoyant. These things were neither known nor knowable at the time of the PUC opinion. And Mr. Blazer tacitly acknowledged that in his opening when he repeated 3 times the quote from the PUC advisory opinion, quote, "at this time," the PUC was careful to emphasize. I said a moment ago that there's new evidence in the record that was not available at the time of the PUC opinion in August 3rd, 2016. It's one example of a broader proposition that CLF will be relying on in its case. That proposition is that the world is changing. Invenergy's witness, Ryan Hardy, discussed that fact at the preliminary hearing of this case here on June 12, 2016. Ryan Hardy talked about the fact that the market is dynamic. The market changes, and changing results in the forward capacity auction, the FCA, shows changing circumstances of whether or not a plant is needed. Sitting in this room on January 12th, when he was under oath, Ryan Hardy said at page 163 of the transcript, pages 6 to 16, "We've seen New England overall in terms of supply and demand tighten significantly in the last few years. And so the capacity price in New England has increased significantly. That is exactly how the market is supposed to work, providing those price signals 3 years in advance so that developers like Invenergy can respond with power generation to fill that gap and to keep the market reliable." What Ryan Hardy said in this room under oath was correct. And we should look at the figures of the FCA forward capacity auction clearing results to see exactly what Mr. Hardy was talking about. So this chart is Ryan Hardy's metric. Invenergy's witness urged you to consider FCA clearing results in judging whether or not this plant is needed. FCA 8, Forward Capacity Auction 8, was conducted in 2014. That was the year that Invenergy was conceived. That was the year in which we have the first correspondence between DEM and Invenergy. The clearing price in the auction FCA 8 was $15. Ryan Hardy was correct. That high clearing price will have the effect of drawing in new capacity resources. FCA 9 in 2015. So 2015 is the year that this docket was opened. It was the year that Invenergy filed its application with the EFSB on October 29, 2015. The clearing price went up to $17.73. That was the highest clearing price of any ISO capacity auction ever. FCA 16. Remember, Ryan Hardy was speaking here in January 12, 2016. That was about a month, 3 weeks before the auction. Auction was conducted on the first Monday in February. Mr. Hardy didn't know what the results would be. But Mr. Hardy said, high clearing price shows that a plant is needed. So 2016, Invenergy had 2 turbines in the auction. They cleared only one of the 2. The clearing price crashed to $7.03. It went down 61% from the previous year. A datum, according to Ryan Hardy's metric, that a plant is not needed. FCA 11 in 2017, if Ryan Hardy was right, the clearing price would be high or higher. Clearing price went down to $5.30, a decrease of another 24% over the 61% drop the previous year. And of course, in FCA 11, that was the year that Invenergy's Turbine 2 didn't clear the auction. FCA 12, 2018, just a few weeks ago, that was the year Invenergy's second turbine was disqualified from the auction. Clearing price of $463, a reduction of 12.6%, beyond the 24% reduction the previous year, beyond the 61% reduction the year before that. If you apply the metric that Ryan Hardy urged on you in this room, this plant is not needed. These results are not surprising because what Ryan Hardy said was true. The market is dynamic, the market changes, and the market reflects whether plants are needed. It's not surprising, but it is embarrassing for Invenergy. The fact is that if you apply the metric urged on you by Ryan Hardy, this plant is not needed. Also on January 12, 2016, in this room, John Nyland spoke. He was under oath. He had a PowerPoint presentation. And on slide 27 of Mr. Nyland's PowerPoint presentation, bullet 2, Mr. Nyland explained that ICR, installed capacity requirement, or net ICR, is the way the ISO determines how much capacity to buy in each auction. He was right. Mr. Nyland explained that the ISO believes that net ICR, installed capacity requirement, may continue to go up, and that this increase in the future of installed capacity requirement is the way you can tell that Invenergy is needed. Well, let's look at the actual figures that have been in ISO auctions since Mr. Nyland spoke here. In 2015, the year this docket was opened, in FCA 9, the net ICR, the actual figure, was 35,142 megawatts. Mr. Nyland spoke before FCA 10 was conducted. If Mr. Nyland was right that the plant was needed, then net ICR would have gone up. Mr. Nyland's prediction was net ICR would go up. That would show that the plant was needed. In fact, net ICR went down. The next FCA, Forward Capacity Auction 11 in 2017, Mr. Nyland told you that ICR should go up, showing that the plant is needed. But ICR went down. Mr. Blazer talked to you about the ARAs, the Annual Reconfiguration Auctions. He was correct. These are annual auctions in which the ISO reconfigures which resources are needed, which are not needed for a capacity commitment period. Remember, as Mr. Blazer said correctly, those auctions happen 3.5 years in advance of the commitment period. So in the first annual reconfiguration auction for the year that Invenergy's CSO, capacity supply obligation, was supposed to start, 2019, the ICR went down again. If Mr. Nyland had been correct and the plant was needed, it would have gone up. Instead, it went down. The reason that I put the ARA here between the auction of 2017 and the auction of 2018 is that's where, in time, that's when the ARA happened. And then again, FCA 12, just a few weeks ago, Mr. Nyland, if he were right that the plant is needed, ICR would have gone up. Instead, it went down. These are the metrics that were urged on you by Invenergy. Mr. Nyland was correct. You look to the ICR, and Mr. Nyland's testimony on page 171, January 12, he explained that net ICR was expected to go up approximately 0.6% per annum for future years. There's an irony here, because in fact, according to the most recent ISO CELT report, Capacity, Energy, Loads, and Transmission, in fact, net ICR for the next 10 years is expected to change approximately 0.6% per annum. Mr. Nyland just made one eensy-weensy little mistake. ICR is going down annually by that percentage, not up. Brings us to our second issue, the issue of carbon and climate. Here, CLF's expert witness is Dr. Timmons Roberts. His testimony, Exhibit 5, that it will be impossible for Rhode Island to meet its short, medium, or long-term carbon emission reduction goals under the Resilient Rhode Island Act if this plant is built. Obviously, that raises the question in everybody's mind, how can Dr. Roberts say that in the teeth of the OER advisory opinion, which Mr. Blazer cited accurately and correctly, and the testimony of OER's expert, Dr. Ellen G. Kuhl, that says that even when this plant is built, Rhode Island will be able to meet its carbon emission reduction goals. The answer here lies in the different methods of accounting between production-based accounting for carbon emissions and consumption-based accounting for carbon emissions. There's one point on which Dr. Kuhl and Dr. Roberts agree, and one point on which they disagree. The point on which Dr. Kuhl, the OER expert, and Dr. Roberts agree is what each of those accounting methods mean. Production-based accounting looks at carbon that is geographically, literally produced in the state. There's a power plant here. Regardless of where the power is consumed, with production-based accounting, you count the carbon from that plant. In consumption-based accounting, in the electricity sector, what you do is you look at the overall fuel mix of the ISO 6-state region, We all know what that is. It's about 49% gas, 28% nuclear, 13% large Canadian hydro, 8% other renewables. You look at the carbon emission profile of each of those different fuel sources, and you account for the consumption of carbon here in the state. So Dr. Kuhl and Dr. Roberts agree what the difference is. Where they disagree is which way we should look at carbon emissions. And Mr. Blazer was right, OER and the EC4 for that matter, both look at consumption-based accounting. It is Dr. Roberts' testimony, and you'll see this in his rebuttal testimony, CLF Exhibit 5. It's Dr. Roberts' testimony that looking at consumption-based accounting for a plant like this is wrong for 4 reasons. First, Dr. Roberts testifies, you see this on page 3 of his rebuttal, he was one of the principal authors of the Resilient Rhode Island Act. It was never, ever in the contemplation of the authors of that statute that one would look at emissions on a consumption basis. Second, Dr. Roberts applies a sort of common sense approach. This is on pages 4 to 5 of his testimony. He says, look, if you do consumption-based accounting, that means that 94% of any electricity carbon emissions produced in Rhode Island gets accounted for out of state, because here in Rhode Island we only have 6%, 6.11% to be exact, of the overall load in New England, electricity load. And the example that Dr. Roberts gives is his words in his testimony, his words are that this is an accounting trick. The example Dr. Roberts gives is, if you use consumption-based accounting, you could build a new coal-fired power plant on Jefferson Boulevard in Warwick and say that you're reducing carbon emissions because 94% of the emissions are accounted for out of state. But at the same time, you could build a new carbon fueled power plant in Burlington, Vermont, and account for those emissions from out of state, because Vermont is only 5 or 6% of New England load, and you could build a new coal-fired power plant in New Hampshire. And by an accounting trick, every one of those states would say, we're reducing carbon emissions. But of course, that makes no sense. Third, Dr. Roberts talks about how dangerous this kind of accounting is by referring to the dangers of climate change. This is in pages 5 and 6. And finally, he talks about the fact that the argument between production and consumption-based accounting has been determined by courts. It was determined by the Massachusetts Supreme Judicial Court in the case of Kaine, K-A-I-N-E, versus Massachusetts Department of Environmental Protection, 474, Massachusetts 278, a case, of course, brought by CLF. One of the issues in that case was consumption-based accounting versus production-based accounting, and the court ruled that CLF was right, that you have to do production-based accounting when you have a statewide regulatory scheme limiting statewide emissions. So the power plant is not needed. The power plant is not needed when you apply the metric urged on you by Invenergy's witness Ryan Harding, looking at the forward capacity auction results. Plant is not needed if you apply the metric urged on you by John Nyland of looking at whether installed capacity requirement is going up or down. Carbon emissions from the plant will make it impossible for the state to meet its carbon emission reduction goals. That brings us to CLF's third witness, Scott Cummings, the Associate State Director of the Nature Conservancy. It's Mr. Cummings' testimony that there would be unacceptable, non-carbon environmental impacts in terms of animal habitat, biodiversity, forest fragmentation versus forest connectivity. It's an interesting fact that when DEM lists what it calls, quote, primary threats, unquote, to Rhode Island forests, the first thing it lists is forest fragmentation. According to DEM, quote, fragmentation subdivides large contiguous areas, creates more edge habitat, and has profound impact on individual and holistic system balances, unquote. Testimony of Mr. Cummings is that the exact site of the Invenergy power plant is a unique ecological location in terms of forest connectivity. This map is taken from Mr. Cummings' rebuttal testimony. It's on page 10 of Mr. Cummings' rebuttal testimony, and it shows the exact site of this proposed plant at a particularly sensitive pinch point. Now, Mr. Blazer talked at some length about the possible potential bias of witnesses. Mr. Blazer had a very good point. And I want to call to your attention the sources of information that Mr. Cummings used for his conclusion that the proposed location for this power plant is a uniquely sensitive, bad location for a power plant. And he cites, in his pre-file testimony, 3 studies. A study by the Nature Conservancy, dated 1968, on the Borderlands region, which is encompassed here. 1968 predates this litigation. He cites a TNC study, the Nature Conservancy study, from 2001, examining undisturbed forests between Maine and Virginia, and points to this location as a uniquely important and sensitive location. 2001 predates this litigation. And Mr. Cummings cites another Nature Conservancy study called Northwest Corner Conservation Plan, which he attaches to his testimony, his pre-filed testimony, as Exhibit C. All of these studies relied upon by Mr. Cummings predate this testimony. And Mr. Cummings also testifies how very, very rarely the Nature Conservancy ever takes public positions in pending litigation. He discusses this in Exhibit 2, page 6, line 22, through the following page, page 7. But the Nature Conservancy took this position, this very, very rare position, in this case, because of the unique environmental importance of this location as testified to in studies dating back to 1968. Mr. Cummings quotes in his pre-file testimony the DEM advisory opinion in this case that, quote, the further fragmentation of one of the largest remaining intact forests in the state will negatively impact area fish and wildlife, unquote. The fourth point that CLF will put in evidence on in this case is the record of lies told by Invenergy to the EFSB, to the ISO, and to the public. Why is this important? The core of what you have to do as an EFSB is to decide between conflicting evidence. To take but one example, Invenergy tells you that the plant is needed, CLF tells you the plant is not needed, and you'll have to decide that. And one of the reasons why the final hearing has live witnesses who are subject to cross-examination is so that you can make determinations of credibility. The evidence will show multiple examples in which Invenergy was just not credible. March 31st, 2016, Burrillville High School auditorium, a meeting of the Energy Facility Siting Board in front of an audience of 700 people. Mr. Nyland, Invenergy's witness, gave information to the EFSB on cost savings for ratepayers, which information Mr. Nyland knew at the time he was speaking was factually incorrect. Invenergy told the EFSB that there would be no cost to ratepayers from this plant at the same time that it filed a lawsuit at FERC seeking to transfer $168 million in interconnection costs from Invenergy to ratepayers. Invenergy did not tell you about that lawsuit, but CLF did. And when CLF told you, and it was picked up in the newspapers, Invenergy was forced to withdraw that lawsuit. But I urge you to read the January 23rd FERC filing that Invenergy made withdrawing the lawsuit. It's very short. It's under 2 pages without the caption. Invenergy said, quote, Clear River continues to believe that such assignment of interconnection costs to Invenergy, not to ratepayers, is demonstrably unjust and unreasonable, and that none of the responses to the Invenergy complaint have shown otherwise. Invenergy said to FERC, the relief sought by Clear River has proven contentious in the Rhode Island Energy Facility Siting Board, and Invenergy is withdrawing the complaint a few weeks after filing it to, quote, eliminate even the false perception of negative ratepayer impact. But Invenergy must have been acutely conscious of what it would look like to FERC and to the world to file a lawsuit, a 50-something page complaint about $168 million, and then voluntarily withdraw the lawsuit as soon as it was revealed publicly. So Invenergy wanted to address that obvious concern. They said on page 2 of 2, quote, Clear River would like to assure the Commission that it submitted its complaint in good faith, believing then, as it continues to believe now, that the issues raised therein present an important issue warranting the Commission's action. Unquote. One thinks of Hamlet, Act 3, Scene 2. Methinks Invenergy doth protest too much. Lack of advisory opinions. CLF incorporates by reference its September 16th, 2016 motion to dismiss based on the fact that 6 of the 13 agencies that were asked to do advisory opinions told the EFSB that they were unable to completely do their jobs because they had been unable to get necessary information from the applicant. Just to be clear, the problem here is not merely the lack of advisory opinions. The problem here is the lack of advisory opinions due to stonewalling by the applicant. And finally, on the matter of misinformation, this will come out on October 31st, when Mr. Nyland is scheduled to be cross-examined. Evidence will show that Invenergy provided false information to the ISO about the project. And when this discussion happens on October 31st, CLF will be very, very, very careful to separate information that is publicly known from what is not publicly known. And when we discuss the stuff that's not publicly known, we'll clear the room. But the following is publicly known. It is publicly known today that Invenergy is on critical path scheduling, CPS monitoring by the ISO. It's publicly known today that the reason Invenergy is on CPS monitoring is because it's so behind schedule. It's publicly known today that the CPS provisions of the ISO tariff appear in the tariff section 3.13, .1, .1, .2, .2. It is publicly known today, this is not subject to the non-disclosure agreement, that as a result of being on CPS monitoring, Invenergy has to file monthly progress reports with the ISO called FCTS, Forward Capacity Tracking System Reports. When we cross-examine Mr. Nyland, we will show that Invenergy has given false information about the project to ISO, which information Invenergy knew to be false at the time it was filed. Now I know the counter-argument, the reason I shouldn't say this in an opening, is because I'm giving Invenergy 6 months and 5 days to plan how they will handle that cross-examination. I'm not worried about that, because the forms have already been filed. And the analogy here is to Mr. Nyland's cross-examination in the Invenergy docket before the PUC, when I asked him about his false statement at Burrillville High School on March 31st. And we'll see the transcript. For 2+ pages, Mr. Nyland dances around the issue and evades it and tries to dodge. But then when the question was put to Mr. Nyland, did you know on March 31st, when you were speaking, that the information you were giving was false? The first word out of Mr. Nyland's mouth was yes. So too with the FCTS forms, the Forward Capacity Tracking System forms. They can correct the forms in a later filing, they can file an amendment, they can explain that they didn't know, but the damage has already been done. The point here is that even if some power plant were needed in New England, which it is not, that's not the location for the plant when you have the Nature Conservancy studies going back to 1968 talking about how this is a uniquely important pinch point. And even if a power plant were needed, which it is not, this would not be the company to build the plant, because you can't give a permit to a company that can't be honest with the ISO, with the EFSB, and with the public. And now we're going to switch into material that is confidential and is protected by the non-disclosure agreement.
Okay. Counselor, please track this. I believe we have to clear
Everyone who has not previously signed a non-disclosure agreement will have to leave briefly. You can either go outside or into the lobby.
On this important issue. I want to thank Mr. Blazer for referring to the September 29th, 2017 QDN, Qualification Determination Notification from the ISO as a 1-year postponement, because on Friday, September 28th this year, Carissa Sedlacek, S-E-D-L-A-C-E-K, of the ISO's Resource Adequacy Department will issue the QDN determination for the next auction, and we should all be focused on that. Mr. Blazer made comments about CLF opposing wind and solar, and I guess I have two things to say about that. One is, obviously, CLF is not on trial here. Secondly, when you look at the renewable energy statutes in Rhode Island, CLF has been involved up to its eyeballs in every one of them, starting with the 2004 Renewable Energy Standard, which we supported in the General Assembly, and we participated in this room in the PUC rulemaking under that. The 2009 long-term contracting statute that gave rise to Deepwater Wind, first in the nation offshore wind farm, was principally written, the underlying statute was principally written by a CLF lawyer. 2011 net metering statute was written principally by a CLF lawyer. That has been so successful that we're now getting controversy and pushback from other environmental groups about the huge solar farms that are popping up all over the state. And Mr. Blazer referred to the Renewable Energy Growth Program, another handiwork of CLF lawyers. Mr. Blazer's recitation of those statutes was largely accurate, but I guess he didn't know from whence those statutes came. I'm glad that Mr. Blazer mentioned the figure $119 million to $365 million in savings to Rhode Island ratepayers, not New England, Rhode Island ratepayers in just the first 4 years of the project. We will cross-examine both Mr. Hardy and Mr. Walker on those figures. And when we do that, we'll have the transcript from today in hand, so we'll know exactly what words Mr. Blazer used. In conclusion, CLF respectfully asks the EFSB to deny the permit requested by Invenergy. The evidence shows that the plant is not needed. In the teeth of the PUC advisory opinion that concluded that the plant is needed, there is substantial new information in the record that was not known then and was not knowable then. If you use the metric urged on you by Mr. Hardy to look at FCA clearing results to determine if the plant is needed, the plant is not needed. If you use the metric urged on you by Mr. Nyland to look at year-over-year change in the net ICR, the installed capacity requirement, that shows the plant is not needed. Mr. Nyland's projection of year-over-year change in the net ICR of about 0.6% was very close to the mark, but current ISO figures show that that is a declining year-over-year figure, not an increasing one, showing that the plant is not needed. The evidence shows that Rhode Island will not be able to meet its short, medium, or long-term carbon emission reduction goals if the plant is built. And the evidence dating back to 1968, a variety of studies by the Nature Conservancy shows unacceptable non-carbon environmental impacts in terms of biodiversity and forest connectivity if this plant is built. And even if a plant were needed, it isn't needed there. The evidence will show that Invenergy has deliberately misstated material facts, sometimes knowingly, as with Mr. Nyland's statement on March 31st in the Burrillville High School in front of 700 people, sometimes knowingly, as with Invenergy's FCTS filings, and sometimes not knowingly, as with Ryan Hardy's repeated mistakes in his projections. So that even if a plant were needed, this would not be the company to build it. It brings us back to where I started when I said, if the plant were needed, which it is not, this would be a harder case, because you would have to balance the need for the plant for system reliability against the known environmental harms. But since the plant is not needed, your job becomes easier. Section 8 of the Resilient Rhode Island Act empowers every state agency, including this one, to act on the goals for carbon emission reductions set forth in that statute. And CLF is asking you to do that. Deny the permit for this plant. Thank you.
Thank you, Mr.